So we're going to start with our first panel this morning. This is a panel that initially, I'll just say, was initially proposed by Noah Rosenblum, who is going to the podium now. It's certainly one of the panels that we were very excited about, trying to get a new perspective from both lawyers and historians. Everybody here is who on this panel is both a JD and a PhD, and trying to rethink the impact of this key moment on international law. So we're looking very forward to this morning. Noah Rosenblum received his JD from Yale Law School, where he was an editor on the Yale Law Journal and a recipient of the Parker Prize in Legal History. He is currently a PhD candidate in history at Columbia University, where he has been funded by a Javits Fellowship from the U.S. Department of Education. He is currently a law clerk for the Honorable Guido Calabresi of the United States Court of Appeals for the Second Circuit, and he did ask me to remind you that nothing he says today should be construed as a political opinion or attributed to the American judiciary. Thank you very much.
Thank you, Steve, for that very kind introduction. And thank you to Steve and to Al for what has already been a really exciting conference. I'm glad to be here. I don't know if we'll be able to live up to Bill's billing, but we're certainly going to try. It's a lot of fun. So the talk that I'm going to share with you today, let me start my timer. I've got 20 minutes. Is that what we said? Okay. The talk I'm going to share with you today comes from my dissertation, which looks at the origins of presidential democracy and traces a turn to presidentialism back to a series of debates about the failure of representative assemblies in the immediate post-World War I period to live up to the challenges of modernity. And while doing that research, I came across a small puzzle in international law, and that's the puzzle that I'm going to be sharing with you today. And the puzzle can be stated in a very simple and stylized form. And it goes like this, that basically there are two different tendencies in international law, and they exist in some tension with each other. And one tendency is what we can think of as the one law tendency, the idea that we should be bringing all the countries of the world or all of the people who are party to the law under a single law. And the other tendency can be thought of as the each his own law tendency, the idea that international law is a mechanism to enable different independent sovereigns to have their own law, each their own law. This is an ineluctable problem. Those of you here in Europe, if you're familiar with the jurisprudence of the European Court of Human Rights, this might be something on your mind. And it's got both of those tendencies, right? The one law tendency, the European Convention on Human Rights, the single court, all the countries in the Conseil de l'Europe under one law. But it's also got the each his own law tendency. So how do you implement decisions of the court? Well, through the Council of Ministers. And then there are principles in the jurisprudence, the concept of subrogation or the margin of appreciation, where we allow each country to have their own law. Okay, so one law, each his own law. The Versailles Treaty, I want to suggest to you today, can be understood as a key moment in the articulation of this problem, that it embodies that tension, and it sort of does something to it that has consequences down the line. And I'm going to point to that very briefly at the end. In particular, it sets up certain possibilities of imperial rule under law. So to try to make this argument about the Versailles Treaty, I'm going to make 3 points. One, that there was something like a unified conversation among public law thinkers in the North Atlantic in and around World War I and its aftermath, especially in the United States, France, and Germany. And this allows us to talk about something like a transnational, international legal sensibility. So that's the first argument I'm going to try to make. The second point I'm going to try to make is that by looking at this sensibility, we can see a kind of shift in an understanding of international law, a bit of a move from one pole, the one law, to the other pole, the each her own law. And then the last point I'm going to suggest is that the Versailles Treaty embodied in an interesting way this tension and did something to it. And I should warn you, we're going to be proceeding in decreasing order of certainty. So the first claim about the transnational legal sensibility, that I know is true from my research. The second claim about the indexing shift in international law, that I think is true, but I'm not positive. And the last claim about the Versailles Treaty, we'll be thinking together on that one. Okay, so what I know is true, the interwar crisis of democratic theory. If you think about the interwar, so that there was an interwar crisis of democratic theory, that is widely known. It's the subject of a really wonderful book by the scholar in the United States, Ed Purcell, from the 1970s. What's maybe less well known about this moment of crisis in democratic thought in the interwar is first that it is, I think, best understood as a product of World War I, and second, that it was global in scope. So there are a lot of national histories about this crisis of democratic thought, but the idea that it was a North Atlantic or even global phenomenon, that's less widely understood. Okay, what do I mean by these 2 points? So first, World War I, and this is where my first slide comes up. This is a quote from James Bryce's amazing study, Modern Democracies. James Bryce was an ambassador from the United Kingdom to the United States. He was a major scholar. And what's he saying here? Well, he's saying that for most of recorded history, democracy just was a threatening term, and it certainly wasn't a way to think about organizing a good government. But something monumental has changed. Here we find ourselves in 1921, and democracy, now it is a word of praise. Popular power is welcomed, extolled, worshipped. The old question, what is the best form of government, is almost obsolete. Okay, 1921. And what has happened? Well, we know what has happened. What's happened is World War I. And there are lots of different ways of trying to understand the connection between World War I and democracy. Jan Werner Mueller has a wonderful argument about the injection of the masses into politics. Adam Tooze, who is no longer with us, has almost a toss-off point in his amazing book, which I can't recommend high enough, where he says that by marrying self-determination to and the resignation of the Kaiser to peace in World War I, Wilson ends up injecting a certain kind of democratic commitment. Although, of course, as we heard yesterday, there were other sources less connected directly to Wilsonianism that animated a democratic, or what looks to the West like a democratic spirit at that time. For my purposes, 2 quick points. First, that there was a global dimension, right? So Bryce is saying not just the best form of government for us, he's saying the best form of government, this is for everybody. And second, that this global aspect, sorry, I just lost my place. And this isn't here, but if you look at the rest of the book, you'll see that what democracy means for Bryce and for democratic thinkers at this time is representative assemblies. It's the parliament. Of course, what this parliament was supposed to be wasn't super clear. So who gets to be a part of it? What kinds of questions does it get to answer? And that's one of the major sources of instability in this period. Other scholars have written more about that instability. I won't bore you with it now. For my purposes, there's only one point I really want to hammer home about the instability that follows on the explosion of democracies, which is that just as the moment of democratic invention was experienced as something that was transnational and global, so too was the sense of crisis or dissolution. So this is another quotation, almost at random, from Nicholas Murray Butler, the president of Columbia University, member of the Carnegie Endowment for International Peace, a major thinker at the intersection of international law, political science, public policy. This is a speech that he's giving to students at the University of Virginia on the occasion of Thomas Jefferson's birthday. And he's saying, in the passage just before this, he's describing how the rise of Mussolini presents a real threat to theories of democratic government. And what are we going to do? How are we going to respond? And all that I want to draw attention to is the toss-off line about, I'm asking you guys this in the United States, but the same question could be posed in Britain or in France, or as it happens in Austria, where 4 years later, Nicholas Murray Butler is giving basically the same speech to the Austrian parliament, although in German this time, and lecturing them about their crisis of democratic organization and how they need to look to the United States in order to understand how to do things better. Great. So just as public law thinkers addressed the emergence of democratic thought in this North Atlantic community, and just as they tried to then, they then similarly tried to deal with the crisis in this sort of transnational context. So the Interparliamentary Union, this really wonderful, strange organization that brings together parliamentarians from all over the world, including the global south, it has the problem of the crisis of democratic theory on its agenda in 1924, 1925, 1928, 1930, 1932, 1933, 1934, and 1935. This other organization, which I adore, the Institut International de Droit Public, founded here in Paris in 1927, similarly puts the problem of parliamentarianism and its crisis on its agenda repeatedly. And so I mentioned before transnational legal consciousness. What is this transnational legal consciousness? What did these thinkers think they were doing? So here I want to look at the next quote, because they were quite self-conscious about what they were up to. They talked a lot about about what their goals were and why they were meeting in this way to deal with these public law problems. So this is a speech that Gaston Gèze, the first president of the Institut International de Droit Public, gives in 1927 when he accepts the presidency. And I can tell you more about this organization during the Q&A if you're interested. It brings together public law thinkers from a lot of fascinating different backgrounds, including several Americans, German thinkers who will become Nazis like Carl Schmidt, but German thinkers who will remain very serious devotees of liberal Weimar republicanism, like Richard Thomas. Okay, so what's he saying? He's saying, we're going to bring together thinkers. I have the hope that with the agreement of all of these great intelligences, the members of this institute, we will contribute maybe to the betterment of the organization and functioning of political institutions in the free states. Thinking all together about the same problems will bring the experts, les savants, those who know, to medium-term solutions whose prestige and influence with those who govern will be that much stronger because they will express at a given moment the juridical conscience of the civilized world. Now, those of you who are up on your international critical legal studies may pause for a moment at the expression conscience juridique du monde civilisé, the juridical conscience of the civilized world. And that ending line is almost a term of art for international public law thinkers. And here I draw heavily on the amazing work of Marty Koskiniemi, the pioneering scholar of international law. The key point for Marty, and this goes back to Eric's wonderful talk from yesterday, is that there was a unified, conceptualizable, liberal imperial project through the 19th century. And that project has deep, deep roots. And its mission was both civilized and civilizing in its own self-understanding. That's what these people thought that they were doing. But that project of liberal, civilized, civilizing imperialism is thrown off course, theoretically, by the Franco-Prussian War in 1872. Because what are these civilized, civilizing people doing going to war against each other in Europe itself? The devastation of the war is overwhelming. And so the public law thinkers who are articulating the sensibility are very upset, and they want to bring the project back on course. And so in 1873, they meet in Ghent, and they found something that becomes the Institut de Droit International, the International Law Institute. And their goal is to express the juridical conscience of the civilized world. And for them, at that moment, what it means is bringing this civilized, civilizing project back under one law. Right? It's bringing the course of world history within the sphere of the evolution of Victorian norms of gentility and sophistication, sometimes at the barrel of a gun, but always under and through the rule of law. As Marty details, that project fails for a variety of reasons. One of the, intellectually, we can talk politically about the problems with it whenever you want at great length. But the project intellectually fails for a second reason, and again, it's war. It's World War I, right? As is well known, World War I fractures many international institutions along national lines. The same thing happens with many of these public law thinkers, and that leaves these international lawyers in a very strange place, because on the one hand, they're now strong nationalists, maybe even xenophobes, deep, aggressive patriots at war with each other, but on the other hand, they were forged in the crucible of an international sensibility. And so what happens? How do they reconcile that? And so now we're moving into the part where what I'm saying is I think true, but I don't really know if it's true. I think part of the way they reconcile that is by transforming what it means to be committed to expressing the juridical conscience of the civilized world. We see that shift, the shift from the one law project of the men of Ghent of 1873 to the each her own law project of the Institut International de Droit Public. And that's attested to in many different ways. So they want to bring about convergence, and that convergence can often be quite dark. So Katharina will be talking at the end about a sort of negative international convergence that we'll see. In my research, I see it in the way that these thinkers, as they puzzle through the problems with democratic government, each in their own way come up with the significance of executive-based leadership as a solution to the problems of parliamentarianism. It's a shared problem, but each is going to implement that problem in their own way, or solution in their own way, each her own law. And that squares with the other activities of things like the Institut International de Droit Public, where they publish comparative law recueils, collections of documents. They look at constitutions from different countries. They try to get parliamentarians to exchange best practices. So that's the bit which I think is true, right, the shift. Okay, now for the part where I really don't know if it's true, but it seems worth thinking about together, which is how the Treaty of Versailles fits in with all of this. And I want to suggest that the treaty embodies this shift in tension and then draw out some of the consequences of that shift. So what do I mean when I say that it embodies the shift in the tension? Well, I think the Treaty of Versailles can be profitably read in either of the two stylized idioms, right, at either pole. It embodies it as aspects of the one law, right, the League of Nations that everyone is supposed to join, the Permanent Court of International Justice, which Chris will tell us more about what happens to that and some of its ideas later. The one law side of it, but then also very much the each her own law part of it. So the very way in which, as I mentioned before, the outcome of World War I is connected to certain notions of self-determination. Back to the League of Nations and its own organization, the way that it's got certain covenants that bind everybody in a kind of top-down way and other ways in which it's a parliament of nations, right, le palais des nations. So to that extent, I think we can look at this almost like the Declaration of Independence as it was analyzed by David Armitage in his wonderful article on the Declaration of Independence, where he says, look, this document participates in the legitimation of one regime, the one law, going back to the humanitarian treaties and the Hague Conventions, but it anticipates the world that's going to come, the world of anarchic states in which international law is this sort of loose connection between separate sovereigns. Okay, and what are the consequences of this? There are a bunch. I just want to point to one and direct your attention to the work of other scholars much better than I, which is that it doesn't just undercut the stability of the treaty, right? As we know from the history, the each her own law aspect is going to make the one law aspect of it a lot harder to realize, but it also creates an opening for the perpetuation of the imperial project of the old gentle civilizers. It allows you to interject Western power into a non-Western context under the rubric of the rule of law, precisely now by promoting the convergence under the each her own law approach. So here, all that I can do, as I said, is point you to the great work of scholars like Anthony Anghie or Karuna Mantana, who writes about an earlier period but also captures this dynamic, or others who write in the tradition of third world approaches to international law, which is one of the most intellectually exciting aspects of international legal thought right now and has taken a great historical turn. And the big point here is that the international law gift of sovereignty was deeply ambivalent, because when you constitute peoples as sovereign, you then have the right, if you are already the bearer of sovereignty, to intervene to promote sovereignty or promote proper sovereign development. Even under the rubric of each her own law, there's a space opened up for interventionism. Okay, so just to sum up what I've tried to convince you of, or at least suggest, the thing that I really have no business talking about, but maybe you find it plausible, that the Versailles Treaty embodies these two distinct approaches to international law, the one law and the each her own law, that this weakened the treaty as an instrument, as a binding legal instrument, while at the same time enabling a new form of imperialism through law, or the continuation under a new rubric of imperialism through law. We can track the international sensibility of which it was a part by looking at what it means to be the juridical conscience of the civilized world from the 1873 Men of Ghent civilizing mission to bring us all under one law to the comparative law of the Institut International de Droit Public, and that in that movement we should see the Treaty of Versailles as right in the middle, as a kind of point of inflection between what happened and what's going to come. Thank you.
Thank you very much. Yes, that is a very stimulating talk and gives much food for thought. The whole question of people like Gez and their relationship to, as you said, 1850s, 1860s birth of international law, and then the sort of major shift that's going to take place in the interwar period. We're certainly sort of anxious to see how the Treaty of Versailles fits into that shift. So that's fascinating. Okay, our next speaker is Benjamin Brady. He is currently clerking on the U.S. Court of Appeals for the Eighth Circuit. He received his PhD in history from the University of Virginia in 2016 and his JD from Stanford Law in 2010. And he will be speaking on the higher legalism of Woodrow Wilson.
And I'll invoke Noah's disclaimer that my views are my own and I'm not speaking for the judiciary today. So yesterday when Professor Zelikow opened the conference, he mentioned the way that President Wilson sort of largely went it alone in conducting U.S. foreign policy during the First World War. And I want to look to law to explain Wilson's isolation, particularly at the Peace Conference in 1919. And there's a tendency historically to associate Wilson and Wilsonianism with either everything that's good about U.S. foreign policy or everything that's bad. So for realist critics, Wilson is the ultimate embodiment of a sort of legalism, moralism that causes problems in U.S. foreign relations. On the other hand, there's a sort of a tendency to think of Wilson as sort of embodying international law and multilateralism and sort of the good things that make us feel good about the United States. But scholars who have actually sort of looked at what Wilson actually says note that he has some not so nice things to say about law and lawyers during the First World War. And I want to suggest today that Wilson's apparent disdain for law and lawyers stems not so much from his rejection of law, but from his commitment to an alternative vision of law that sort of separated him from the legal mainstream in the United States, and that played a major role in the failure of the League of Nations within the United States when he returned from Paris. So the beginning of the 20th century is, legal historians have noted that it's sort of the high point of what they call classical legal thought or legal formalism. And the basic focus of legal formalism is boundary drawing. Courts, judges draw boundaries, separating one state from another, person from public, private, so forth. So, I mean, to give an example, Union Pacific builds a railroad through Nebraska. Sparks fly off a train and start a fire. Where does liability fall? It's the role, there's probably not a statute addressing this precise issue, so it's the role of courts to say, does Union Pacific have to pay the farmer, or does the farmer have to bear the own costs of the destruction? And the general idea is that courts could do this because they were applying general principles through deduction and reasoning by analogy. Maybe this is the first fire started by a train in Nebraska, and so we have to look to how we handle cows trampling on crops, draw an analogy. But the general sense was that law was neutral and that judges in doing this were objective and scientific in a way. But, the sort of ultimate embodiment of this within the nation writ large, Wilson's successor as the McCormick Professor of Jurisprudence at Princeton, Edward Corwin, termed dual federalism. And the basic idea of dual federalism was that the federal government and the states were each supreme in their own sphere. And the federal judiciary sort of wasn't so much a part of the federal government as sort of above the system, and it policed these boundaries and sort of ensured that each side remained within its proper sphere. And the system worked remarkably well and helped in large measure to achieve the tremendous economic integration in the United States, the creation of a truly national market in the years after the US Civil War. And the sort of ultimate embodiment of this way of thinking about law in the foreign policy realm was Elihu Root, who was, I guess you could say, the leading statesman in the years before, leading American statesman in the years before the First World War. And as I read Root's program, he essentially wanted to sort of create a dual federalism for the world. Root had been a New York corporate lawyer, and supposedly McKinley wanted a lawyer to deal with the aftermath of the Spanish-American War, and so brought him in as Secretary of War. And then when Roosevelt became president, he switched and became Secretary of State. And this, Root sort of had a tough job because as he saw it, the sort of American public's taste for sort of the imperial venture was fading. And he needed sort of an alternative foreign policy in order to sustain the Roosevelt agenda in the world. And he looked and put a very strong emphasis on on Latin America and really emphasized Latin American states' sovereignty. And it's sort of many scholars have seen it as sort of a forerunner to the good neighbor policy that comes later. And I think he genuinely believed that he was sort of resetting American foreign relations after and trying to put it on a fresh track, less interventionist. But it was also somewhat self-serving because under the sort of prevailing system of international law at the time, states were sovereign over their own internal affairs. And if Latin American states were truly sovereign, then Germany and Britain incursions into the Western Hemisphere were unacceptable. And so it was sort of a reinforcement to the Monroe Doctrine. But despite this, and so Root made a tour of Latin America and really sort of talked up the new U.S. respect for Latin American sovereignty, particularly in South America, but also in Central America too. But he balanced this emphasis on sovereignty with a strong emphasis on economic interdependence. And he thought, he had almost a gendered conception of relations between the United States and Latin America. He saw the United States and North America as sort of manly Anglo-Saxons who were producing goods that would be poured out into a receptive, more feminine Latin America. And so at this very moment, there was this natural convergence between American interest and Latin American interest. What was good for the United States also happened to be good for the world. But he also, despite this sort of rosy view of economic interdependence, he knew that disputes would arise, and he also knew that European entanglement with Latin America would also cause disputes that had happened particularly in Venezuela several years earlier. And so his solution to this was courts, starting with arbitration panels, but he ultimately wanted to develop a world court. And the idea was, and I think the model in his mind was the federal judiciary within the United States. There would be a sort of body of international judges who had, just as sort of federal judges had a national outlook within the United States, they would have an international outlook. And they could resolve disputes applying these sort of objective develop a body of law, apply deduction, reasoning by analogy, solve these disputes through neutrality, and eventually you would have peace and an end to conflict. Well, then the First World War happened, and it seemed to belie the entire program. And we talked a little bit yesterday about Belgium as victim, and Belgium sort of, for Root, embodied the problems with this system because Belgian sovereignty was crystal clear in international law. You didn't need a court to tell you that, and yet the Germans overran it anyway. And so it seemed like maybe this program wasn't what the world needed after all. But they, Root and the other sort of international lawyers, and this was sort of a who's who of the American political establishment, President Taft, Secretary of State for Wilson, Robert Lansing, Andrew Carnegie. Really, this was also the era of the founding of the American Society of International Law, the American Journal of International Law. They sort of doubled down on their program, and they said, what's missing is maybe a sanction. We need a sort of sanction to make this program enforceable. And working particularly with British thinkers, the idea emerged for a League of Nations, and in the United States, these thinkers like Taft were involved in the League to Enforce Peace, which was basically going to take this court-centered agenda and add a sanction. So if the First World War sort of cast the international vision of legal formalism as developed by Root into doubt, classical legal thought, legal formalism was also under strident attack at home. This was the era of the progressives who said, look, judges aren't neutral. They favor capital over labor. This idea that you can apply principles neutrally is silly. So I guess you could say Roscoe Pound, who became dean of Harvard Law School, Oliver Wendell Holmes on the Supreme Court, but then particularly Louis Brandeis, who Wilson put on the Supreme Court, developed an alternative jurisprudence to classical legal thought that scholars have labeled sociological jurisprudence. And the sort of heart of sociological jurisprudence was that experts could study social problems, and rather than having a court sort of apply supposedly neutral principles, you go to the legislature, who can sort of recognize that each problem is sort of its own thing. They could apply this expertise and craft solutions. And so there was still a sort of optimism that problems could be solved, but rather than doing it through courts, it would be done through legislatures. And I want to suggest that this vision of law really underlay Wilson's agenda as he went to Paris. He had obviously had a deep engagement with these issues teaching at Princeton, although when he became governor of New Jersey, his sort of time to stay abreast of the sort of latest trends in the scholarship quickly eroded, he confessed, although he noted that he had friends who sort of updated him on the latest developments in legal scholarship. But I think if we look at Wilson's sort of program at Paris, it rejects each of the key tenets of Root's program. So in the first place, Root strongly emphasized sovereignty as the principle that underlay his system. And for Wilson, sovereignty obviously had a place, but it wasn't the be-all, end-all. The goal wasn't to have courts sort of clarify where sovereignty begins and where it ends. I think the best evidence of this is Article 10, obviously the sort of most famous and controversial part of the League of Nations Covenant. And in Wilson's original draft, Article 10 was actually much more radical than, as scholars have pointed out, the lawyers that Wilson so detested and didn't want drafting the peace treaty ultimately whittled it down. But the original version said that the contracting powers accept without reservation the principle that the peace of the world is superior in importance to every question of political jurisdiction or boundary. So there's another principle, the peace of the world, that trumps sovereignty. Sovereignty isn't the means of peace. Peace is something separate. And even though that language ultimately came out of what became Article 10, Wilson sort of was able to keep the same principle through Article 11, in which which noted that threats of war implicated all members of the League. And so as Wilson toured the United States promoting the Covenant of the League of Nations, he emphasized again and again the friendly right of each member of the League to bring to the attention of the Assembly or of the Council any circumstance whatever affecting international relations which threatens to disturb international peace or the good understanding between nations upon which peace depends. Those were his words in 1919. He said it again in Kansas City, the privilege of any member state to call attention to anything, anywhere that is likely to disturb the peace of the world or the good understanding between nations. And so this was, I think, quite a radical vision in which sovereignty gave way to another principle, this idea that the League could investigate a nation's internal affairs. It could address these sorts of problems. It's quite radical and a very deliberate rejection of the sort of vision of sovereignty underlying Root's mainstream agenda that had defined American foreign policy since the first decade of the 20th century. In addition, Root had this sort of rosy view of economic interdependence between the United States and Latin America. Obviously, by 1919, there's a Bolshevik revolution. That Root view is a lot less tenable. And so another sort of Wilson's goals at Paris was to address economic instability, turmoil between labor and capital. And he saw the League as a means to address these sorts of issues. It would have a continuing role in sort of, as he said, the seed of war in the modern world is industrial and commercial rivalry. So the League of Nations would, in its responsibilities to promote the peace of the world, would sort of address these problems. He talked about the breakdown of empires in Central and Eastern Europe, and now filled with turbulent masses without stable government, unaccustomed to self-control and fighting among themselves like children of dragon's teeth. So these are the sorts of things that the League would address: overriding sovereignty, looking at new problems, not just sort of adjudicating disputes, but addressing things like labor strife, and political instability within nations. And also just the idea of self-determination he recognized meant that sort of the natural sort of borders would have to give way because of concerns about separation. The League would step in and take responsibility so that nations could sort of rest easy. It was also a safeguard against revolution. Revolutions don't spring up overnight, Wilson explained. They come because men know that they have rights and that they are disregarded. And one of the chief efforts of those who made this treaty was to remove that anger from the heart of great peoples. And finally, and as I wrap up, I'll note that sort of for Root, the heart of international law was courts. The goal was to create this international judiciary. Wilson had no time for courts. He didn't care whether the League, if it had been up to him, there wouldn't have been a court in the League of Nations. And I think the sort of understanding Wilson as a sociological jurist, as opposed to sort of a traditional formalist of the Root vein, is to compare what Wilson says as he's promoting the League of Nations with a famous dissent by Justice Brandeis in a case that actually emerges out of World War I. So in 1918, the Supreme Court heard a case in International News Service v. the Associated Press. And basically, because of the war, the International News Service was having trouble getting news bulletins out of Europe. And so they appropriated the AP's news. And this case went to the Supreme Court. And the Supreme Court sort of crafted a solution giving Associated Press relief. But Justice Brandeis, was famous for his dissents, wrote a very sort of notable dissent in which he said, to give relief to the Associated Press would involve more than the application of existing rules of law to new facts. It would require the making of a new rule in analogy to existing ones. But with the increasing complexity of society, the public interest tends to become omnipresent, and the problems presented by new demands for justice cease to be simple. So this is sort of a classic summation of the agenda of what I've called the sociological jurist. This rule by analogy doesn't work. And instead, what we need is legislatures who can look at problems, study them, and craft the sorts of solutions that what Brandeis said courts were ill-equipped to make. Legislatures could prescribe the detailed regulations essential to full enjoyment of the rights conferred, or to introduce the machinery required for enforcement. This is how Wilson conceives of the League of Nations, this role as a sort of global legislature that can study problems and find solutions. And so in closing, I'll just say the great Wilson scholar Arthur Link suggested that Wilson had sort of a higher realism. And I would sort of suggest that in some ways, rather than being against law and lawyers, Wilson had what we might refer to as a higher legalism. And I don't necessarily mean that to endorse it, but simply to say that while Wilson missed a lot, he did understand that Root's vision was ill-equipped to address a lot of the complexities of the modern world that the First World War and the Bolshevik Revolution had revealed. While his program didn't solve these problems, he at least understood that any viable system that emerged after the First World War had to address them. Thank you.
Thank you very much, Ben. It's a fundamental question and a fascinating question. This tension that continues to drive international law. This tension between a sort of realist versus a more formal liberal vision, and how sometimes those traditions are squared within the same context. And it's very hard to find where somebody would fall on either side. And then the way democracy, going back to Noah's earlier comments, the way democracy in the works of somebody like Brandeis or Pound fits into this more radical, critical critique of legal formalism. So, looking forward to discussion on that. Our next speaker is Chris Casey. He received his JD and PhD at Berkeley, and was a Goli postdoctoral fellow at NYU School of Law. He now works at the Library of Congress, where he just explained to me he's a researcher at the Library of Congress, doing a number of things, but largely for Congress itself, including as he put it, sort of sometimes people have a lot to learn about what is actually involved in the issues that are coming forward, and he's very much responsible or involved in trying to make some of those historical issues very clear, which is it's very nice to know that our congressmen and women are in the good hands of history PhDs. So he will be speaking on the topic, a sort of straightforward, very powerful title, Sovereign Commerce.
Yeah, so like my colleagues, I have to say that my views are not those of the Congress of the United States. I think we need somebody from the executive just to round out the declarations. What I'm going to be really speaking about is the place of individual people within international law, and the role of Versailles in shaping the way in which individuals were dealt with in international law in the 20th century. Like Ben mentioned, in the aftermath of the First World War, there are really these two competing visions of how international governance should be done. One model, as was mentioned, was focused on creating a parliament of states, an international legislature, and the other focused on creating an international court that would develop and enforce international law. And it was that second option that had been ascendant in the decades prior to 1914. The establishment of an international court had been the subject of several international peace conferences before Versailles, most notably at The Hague in 1899 and 1907, which had established the still functioning at the time of the outbreak of the war and at the time of the Versailles Conference, the Permanent Court of Arbitration. In its short 14 years of existence before the outbreak of the war, the Permanent Court of Arbitration, the PCA, had resolved 14 disputes, roughly one a year, which isn't bad, I guess, for a new international court. But this tradition of resolving international disputes through judicial methods was much older than 14 years. Throughout the 19th century, thousands of disputes had been handled through a quasi-judicial process known as public international arbitration. None, to be sure, dealt with the assassination of an archduke, but they dealt with contentious issues like border adjustments, maritime boundaries, violations of neutrality. Maybe not issues of state survival, but things people certainly would get hot and bothered about. But that said, far and away the most common kind of dispute resolved through this process were those involving harm done to individuals by foreign states. Indeed, harm to nationals or their property abroad was arguably the most common source of state-to-state disputes in the 19th century. Just to cite one statistic, between 1830 and 1900, the United States employed military force abroad, according to its own count, 75 times. 60 of those 75 were at least premised upon the protection of American nationals or property abroad. Thousands of cases had been heard or adjudicated over the 19th century in which states made claims on behalf of their nationals who had been either injured in their person or in their wallet by the actions of foreign states. Indeed, of the 14 cases that the Permanent Court of Arbitration heard before the outbreak of the First World War, 9 involved, at least in part, claims made by states on behalf of their injured nationals. All of this led one scholar in the 1920s to declare that state responsibility to aliens was far and away the most well-developed sector of international jurisprudence. But the key part is that these claims were all made by states on behalf of their nationals. In none of these instances could individuals themselves bring claims without the support of their state. The state had to go to bat for you. It claimed, through analogy, to be injured, since it represents the people. An injury to a person is an injury to the sovereign. But in the first 2 decades of the 20th century, states were becoming very reluctant to bring these cases. Speaking before the International Congress of the Chambers of Commerce in 1911, Max Abt, a notable German businessman and lawyer, complained, quote, "Unless it is quite extraordinary case in which national questions come into play, states will almost always find reasons for refusing diplomatic intervention these days." Edwin Borchardt, the foremost global expert on the topic and at the time the law librarian of the Library of Congress, observed in 1913 that because of the increasing, quote, exploitation of backward countries by foreign capital, end quote, foreign offices had begun to exercise more careful scrutiny in the case of a breach of contract rather than in personal injury or undue arrest. And in contrast to the bellicose language of the mid-19th century, where you get all this rhetoric about, I'm a Roman citizen, the strong arm should follow a Brit wherever they go. The governments of Europe had begun to take a far more cautious approach. The French foreign minister in 1907, Stéphane Jean-Marie Pichon, speaking before the Chamber of Deputies, said, quote, "There is no doubt, gentlemen, that diplomacy cannot simply follow behind all of the financiers who risk their capital in their more or less adventurous investments. We cannot risk our forces and engage the politics and the foreign relations of a country in all of the fortunate or unfortunate speculations of the great businessmen, the financiers, and the bankers who would allow themselves to be imprudently carried away." And so it's with diplomatic protection, the sort of advocacy on behalf of nationals abroad, becoming less certain and more unwieldy for dealing with increasing numbers of international commercial disputes against sovereign states, that international jurists, particularly those of German extraction, began to advocate for the establishment of a new international court to complement the permanent court of arbitration in The Hague. Hans Weberg, a prominent international lawyer and pacifist, wrote a treatise in 1911 advocating for an international court to deal with claims by private creditors against debtor states. Max Abt, who's likewise complained that since state intervention was no longer sufficient, that the only way left to deal with the problems created by that was creating a neutral court of arbitration, which would have the right of deciding cases which are brought by subjects of a contract state against another contracting state. And he sent a letter of the effect to the German chancellor advocating that he advocate for an international court that could hear the complaints of individuals. And they almost always talked about creditors. Very rarely were they talking about the stateless as becomes, who are often most commonly thought of as being the subjects that are trying to get access to international courts. This subject was then at the center of the proceedings of the 1912 Congress of the Interparliamentary Union, which Noah mentioned earlier, quite a fantastic little organization. At that gathering, Philipp Zorn, one of Germany's premier international jurists and the country's representative, he had been the country's representative at the Hague Peace Conference in 1907, he proposed an establishment of a court to decide on issues of international law between states and individuals. And then Henry Lafontaine, the famed Belgian lawyer who would take home the Nobel Peace Prize the next year, he agreed, saying, quote, "Grave difficulties arise each moment between individuals belonging to one state and dealing directly with the government of another state, and that individuals engaged in foreign businesses were," he argued, "being forced to plead before the tribunals of foreign states whose judges can be influenced by the political and economic environment. And there is a major interest in having a Supreme Court that can escape such influences." At the close of the conference, the Interparliamentary Union declared that the time had come to form a permanent judiciary to deal with disputes involving private persons, whether in their relations to foreign states. And then again in 1916, in the middle of the war, Henry Lafontaine, in conjunction with the Interparliamentary Union, proposed a peace plan, again centering on a court that would be open to individuals. And he said nearly all jurists had advocated for that enlarged competence. There's maybe a bit of an exaggeration there. But as the world came together to make peace, Wilson's vision of a parliament of states took center stage, but the law was not absent. Article 14 of the League Covenant required that the Council formulate and submit plans for the establishment of a permanent court of international justice. And in accordance with the treaty, 10 of the world's most prominent international jurists assembled the following summer at the Peace Palace in The Hague, the home to the Permanent Court of Arbitration, which was, again, still functioning. And among the subjects up for debate were just what kinds of cases the court would hear. La Fontaine, who was, the Nobel Prize winner, again, was on the advisory committee and spoke up when the issue of whether individuals should have access to the court. And he said that it might be considered, he urged, whether the right to have recourse to the court should not be given to some extent to private individuals. By way of example, he noted that it sometimes happens that a private individual who has made a contract with the state finds it impossible to obtain justice against it. In the realm of economic relations, Fontaine argued, a certain equality should exist between the state and the individual. Bernard Loder, the then member of the Supreme Court of the Netherlands and soon to be first president of the Permanent Court, agreed with Fontaine. He said that he saw no reason for limiting the competence of the court by stipulating that private individuals must be represented by their governments to have access. Albert Lapradelle, France's most eminent international legal mind, arguably, brought up the issue of criminal liability and noted that because people were being held as tried for violations of international law in criminal tribunals, they should likewise have access to hold states accountable. And finally, Elie Root spoke up in support of the idea, but he did express doubt as to the feasibility ultimately, and pressed the committee to go for the safer route, leaving it open only to states for now. And so overnight, or by the next day, it had been decided that the court would only be open to states, since other representatives argued that since everyone was represented by a state, whether individuals had access would be irrelevant, since the state could espouse their claim, an oversight that would be made obvious in the first few years of the new court's operation, when it would receive hundreds of applications from stateless individuals pleading for the body to hear their cases. Now, so arguably the judicial version of Versailles failed in this regard, but across the sea from Paris, another organization came into play to give individuals access to an international court. On the sandy boardwalks of Atlantic City, the business leaders from around the world, these self-styled merchants of peace, gathered to form what they called a Businessmen's League of Nations, which they later christened in 1920 the International Chamber of Commerce. And over the next 20 years, the International Chamber would become the most influential non-government organization at the League. It stationed itself at Geneva. It was present in almost every conference. It was represented. There would be a representative. It would just all be states speaking, and then suddenly they would say, "Oh, the representative of the League, of the ICC, opined in," which is quite strange. And as the ICC was well aware, the world had changed. The 20 states that had composed Europe in 1914 had become 27. There were 12,000 miles of new borders, which brought with them new customs formalities, new rules regarding entry into the legal profession, and new judges. The world had just seen Mexico and Russia engage in the two largest expropriations of private property and sovereign debt in modern history. I mean, at an economic conference shortly after the war, a British diplomat noted that the largest obstacle preventing the resumption of trade and investment in Central and Eastern Europe was, quote, the reluctance with British traders feel to submitting their disputes arising between themselves and their customers or the states of Eastern Europe to the tribunals of these new semi-civilized states. And I mean, I guess you can sort of imagine. I mean, would you want to wager your fortune in an Estonian court that began operation last year? So it shouldn't be surprising that the first item on the Chamber's agenda was the creation of a court, a private arbitral court to hear a variety of international business disputes, and one in which states would exist on the same plane as any other individual, merchant, or investor. Etienne Clementel was the first president of the International Chamber of Commerce. He had been France's wartime Minister of Commerce, a prominent member of the French political establishment, and had, in addition to his duties as a senator then, also took the helm of the ICC's nascent court, which gabbled itself into operation in 1923 to widespread acclaim. And one of its first cases involved a contract dispute between a sovereign state and an individual. But how to enforce such decisions was the question on the mind of many of those involved in the ICC's court. At the court's inaugural dinner, the director of the League of Nations legal section gave a speech in which he acknowledged the challenges presented to international arbitration by national laws and customs, which simply didn't recognize arbitration clauses or the enforcement. But he pledged that the League's secretariat would, insofar as possible, encourage the practice and development of arbitration. And encourage the League did. Over the next several years, the Chamber of Commerce and the League would together craft a system of arbitration. In a letter addressed to the Secretary General, the director of the Economic and Financial section of the League wrote that the development of arbitration of investment disputes seemed to be, quote, one of the most useful things that the League could do, end quote. And so the Economic section went to work shaping two multilateral treaties, the Geneva Protocol on the recognition of arbitral clauses and the Geneva Convention on the enforcement of arbitral awards in 1923 and 1927, respectively. Now, to sort of conclude, the failure of Versailles' judicial counterpart in The Hague to take into account the facts of individual international life would have dramatic ramifications in the shape of foreign investment in the 20th century. These two treaties that I just mentioned were the first significant pieces of what would become the contemporary investor-state dispute settlement regime, ISDS, which frequently sees individual investors hail sovereign states before private, some would say shadowy, tribunals. They win judgments and they do collect their awards. Its efficiency at providing a forum for capital prompted the largest European protests since the Iraq War, making ISDS, in the words of the EU's trade minister, quote, the most toxic acronym in Europe. And in response, various European jurists, scholars, and diplomats have recently proposed a public international investment court system, and perhaps this time, unlike at Versailles, they'll get a little further. Thank you.
Thank you very much, Chris. And again, this sort of seeing the intersections between this sort of transformation of international law on the backdrop of massive shifts in commercial claims and commercial enterprise and arbitration. That's a fundamental aspect that came up to some extent yesterday, but that we need to always keep in mind. So our last speaker on the panel is Katharina Isabel Schmidt, is a PhD candidate in history at Princeton University and JSD candidate in law at Yale Law School. Her work is situated at the crossroads between modern German history, legal history, and the history of science, which sort of very promising kind of intersection of disciplines there. Schmidt's research is currently exploring how ideas about law traveled between Europe and the United States, largely in the 20th century, and she will be speaking to us on liberal internationalism and the rise of Nazi life law.
All right, thank you very much. So good morning, everybody. It's a great pleasure to be here and speak to you all today. Thank you very much also to the organizing committee for making this conference possible. I've learned a tremendous amount already, and I hope that you too will take something away from the next 20 minutes or so. So here goes. Though I did my fair share of international legal studies in law school, I would hesitate to call myself a historian of the field. My research, in fact, fits squarely within national German history. In my dissertation, I traced the origins of Nazi life jurisprudence to the pre-World War I free lawyers, a group of German Jewish critical legal scholars who fought against the strictures of Wilhelmine legal liberalism by reference to the Protean concept of life. Law to the free lawyers was not what the statute book said it was. Instead, it was to be found in action, in the life of the localized German people. A good 20 years later, Nazi jurists like Carl Schmidt took up free law ideas about law and life, with Schmidt proclaiming in 1934 that all law emanates from the life law of the German folk. Did free lawyers and Nazi jurists mean the same thing when they talked about law and life? Well, to some extent they did, though not quite. In my dissertation, I thus show how life between 1900 and the 1930s left the realm of culture and came to be understood unequivocally in racial terms. Now, given that my expertise lies elsewhere, what might I have to contribute to a panel titled International Law in the Wake of Versailles? What I have to contribute, I should think, is a frequently overlooked reason for why the Versailles system failed, that reason being a fundamental shift in German legal culture and consciousness before 1933. Interwar German jurists moved from being firmly committed to a legality that was unquestioningly formal and to a might makes right legality centered on racialized notions of life. And this shift in national consciousness, I propose, resonated in the international sphere as well, as early as 1919. While the Versailles system, with the League of Nations at its core, represented formal, positive, scientific, ideal, and ultimately liberal legality, World War II gave expression to an alternative, hierarchical life legality in line with Nazi blood and soil ideology. That the Nazis were at odds with and ultimately to blame for the demise of interwar internationalism is nothing new, of course. What I hope to add to established narratives, however, are three things. First, that Nazi visions of world order were not just a critique or a reaction to liberal internationalism, but a coherent normative system with its own guiding principles and values. Second, that this system was premised on a conflation of categories conventionally thought of as distinct: the ideal and the factual, the moral and the immoral, the internal and the external, as a consequence of which the separation between foreign and domestic policy appeared increasingly obsolete. And third, that German thinking about life, and by implication death, in and through law, preceded the Hitler years by several decades. Building on free law ideas from the late Wilhelmine period, early Weimar jurists had already begun to turn away from viewing law as statutes, contracts, and treaties, and towards viewing law as all-encompassing life, which would have shaped their attitude towards Versailles, of course. It is German jurists' incipient turn to life in the wake of Versailles that I want to focus on today. So my presentation has three parts. First, I want to contrast the formal, liberal legality of the system set up at Versailles with the might makes right approach espoused by leading Nazi jurists. In this context, I will also say a couple of words about the changing relationship between national and international law, domestic and foreign policy during the 1920s. Against this background, I then introduced my research on the late Wilhelmian German free law movement and the turn to life discourses in law they affected, a discourse that survived World War I and the Weimar period, only to be appropriated by leading Nazi jurists. Part 3 will then be dedicated to some more general ruminations about the role of law and legal thought in international order, which I hope will broaden the discussion beyond our panel to include the rest of the room. So whatever other reasons there are or may have been for the failure of liberal internationalism, and we've talked about quite a few of these so far already, the rise of Nazism in Germany is certainly something we should also talk about in this context. After a period of relative stability, beginning with Locarno, the global economic crisis of 1929 cast the League into turmoil, calling into question cooperation and entanglement at the international level. Japan, Italy, and Germany see the rise of authoritarian governments and start pursuing separate economic and security spheres. As soon as Hitler comes to power, he makes good on his promise to leave the League. The Nazis remilitarize the Rhineland, merge Germany with Austria, and annex parts of Czechoslovakia, all in direct contravention of the Treaty of Versailles, before launching an attack on Poland on the 1st of September 1939. The League looks on more or less helplessly as Europe and then the world become embroiled in yet another deadly conflict within a quarter of a century. What is important to bear in mind here, I think, is that there was method to what prima facie appeared as Nazi madness, both at home and abroad. The Nazis, French historian Johann Chapoutot reminded us just recently, were quite simply people. They were people, he says, who came of age and lived in a specific set of circumstances. What the Nazis have in common with all other humans is the fact that their lives took place within a universe of meanings and values. My presentation today, then, constitutes an attempt at recovering this universe of meaning and values with a particular focus on Nazi visions of world order. In Governing the World, published in 2012, Mark Mazauer referred to Nazi ideology as a sustained critique of the dominant assumptions of liberal internationalism. Drawing on Chapoutot, I would like to go a step beyond that today. As such, I will look at Nazi visions of world order not only as a critique of liberal internationalism, but as an alternative, hierarchical life legality in line with Hitler's blood and soil ideology. Now let's consider what this life legality looked like in practice. In a 1934 treatise on international law and National Socialism, Carl Schmidt explained that for us, that is to say for the German people, there is only justice or injustice. Pernicious laws and immoral laws are not valid laws to us. And in doing so, Schmidt revealed two things. One, that the letter of the law was less important than its life. And two, that it was only the German perspective that mattered to the German in terms of law. And indeed, Schmidt's reference to pernicious and immoral laws was an apt description of how the Nazis felt about Versailles. Ostensibly, the league system had been built on self-determination and related principles, as we've heard throughout this conference. It had presented itself as prescribing rules of universal application, rules formulated largely without regard to cultural or economic difference. Whatever else Schmidt may have been, he was certainly a perceptive critic of liberalism, and so he called the system out for its hypocrisy, arguing forcefully that for Germans at least, the Versailles Treaty was a pernicious and immoral instrument that simply wasn't valid. To Schmidt and other Nazi jurists, this is what the situation looked like. German populations living in Poland, Czechoslovakia, Austria, and other places had been forbidden from joining the folk, the German people. Germany had not been part of the negotiations, but had had the treaty imposed upon it by the Allies. Indeed, Germany had been prohibited from joining the League until as late as 1925, 1926, and had been singled out in other ways for a war its enemies had forced it to lead. Germany alone had been made to pay quasi-ruinous reparations and to give up its colonies, while Britain and France had got to keep theirs. The minority treaties applied to some states but not others, not to even mention the mandate system. So much for self-determination and sovereignty, so much for liberalism and universalism. From the perspective of Germany, which was the only perspective, after all, that mattered to Schmidt, the Versailles Treaty was simply not a binding instrument and could be violated with impunity. And in the end, this is exactly what happened. But the problem for Schmidt and others was not only that Versailles hypocritically fell short of the liberal internationalism it had so ceremoniously proclaimed. The problem lay with liberal internationalism itself. Liberalism, to the Nazi mind, obscured and obfuscated what life was really about. It was a violation of what Chapoutot referred to the most basic laws of nature. The Germans, after all, considered themselves to be the most natural people of all, a people that quite literally lived and breathed the laws of nature. As detailed in Mein Kampf, natural life to Hitler and his followers was struggle, a struggle between races with Aryans meant to come out on top. The racial German community, the Volksgemeinschaft, consequently became the be-all and end-all of German existence. People outside the folk, non-Aryans, didn't matter. Even individuals as part of the folk didn't matter. Only the folk as a unified racial organism mattered. In addition to maintaining its racial health and purity, the folk needed to acquire Lebensraum, living space, to do what organic entities need to do: procreate, reign, fight, grow, and survive. And law had to reflect these needs. Our law originates from the life law, the Lebensrecht of the German people, proclaimed Schmidt in 1934, as I mentioned at the outset. He did so in an article defending what historians have referred to as the Night of the Long Knives, Hitler's killing of Röhm and other SA elites. This then was Nazi jurists' illiberal or anti-liberal alternative at home and in the world. This was life, or for that matter, death legality. Whether an action was forbidden by the letter of the law, such as the law forbidding the killing of one's political opponents, was completely irrelevant. Relevant was only whether the action in question was expedient to the life of the German people. Importantly, the term Lebensrecht, variably translatable here as life law, law of life, life right, or right to life, had multiple meanings in this context. For one, it denoted Germany's right to life as a people attached to a particular living space, Lebensraum, a people in need of additional territory to pursue its ancestral imperial purpose. What is more, life law, or life right, denoted the particular normativity that inhered the folk ways of the German community itself. Folk ways that made racial outsiders, like the Jew, a persona existentially non grata. folkways that considered war and death not as a threat to human flourishing, as did, for example, the Kellogg-Briand Pact of 1928, but as integral, as central to life. Lebensrecht, translatable as either life law or life right, tied together Germans' inner and outer reality, their relationship with themselves as people, as well as their relationship with other peoples of the world. Through Lebensrecht, both the Nuremberg laws and the war for Lebensraum in the East emerged as two sides of the same coin. And this, of course, had implications for Nazi visions of world order as well. The Nazis, in short, sought to put the biological folk, the people, back into what the Germans still knew as Völkerrecht, the law of peoples, at a time when everybody else had begun calling it international law, the law of nations. What this meant was that a number of distinctions that had characterized liberal legal science up until the 1930s no longer held up. Nazi life lay somewhere between morality and immorality, somewhere outside the bounds of norm and fact. And life, concerned as it was with procreation, empire, fight, growth, and survival, saw no point in distinguishing between the national and the international, domestic and foreign policy. Okay, so we have seen that the Nazis were, for all intents and purposes, people who operated on the basis of ideas that cohered into a larger normative whole, on the basis of ideas that at least to them made sense. We have also seen life law as not just critique, but counter-ideal to what the Nazis perceived as Versailles' hypocritical internationalism, a counter-ideal that prioritized racial belonging over other sources of normativity and over other sources of rights. And finally, we have seen that life law did away with conventional distinctions, including that between foreign and domestic policy. Put together, I would suggest to you, these three observations raise important questions about the origins of Nazi life law that have so far remained unanswered. Where does thinking about law in terms of life come from? When does it start? And is life law necessarily tied to Nazi ideas? Chapoutot and others seem to suggest that life law got started in 1933 and that it is inextricably interlinked with Nazi racial and territorial ideology. But I don't think that's quite true, and I think it's important to get it right. As I show in my research, the provenance of Nazi life law is much more complicated than historians of law and the Third Reich have understood so far. Recovering its story, I argue, allows for alternative ideological pairings, for alternative timelines and narratives, including narratives of Versailles and its aftermath. Life law was thus born around 1900 as a language to critique mainstream German jurisprudence. It was far from destined to ultimately undergird a fledgling Nazi state. Indeed, references to life as a source of normative guidance were the conceptual glue that held together a great number of jurists across the political spectrum. As such, my dissertation features a diverse cast of characters who were all committed to law as life in some way or another. Gustav Radbruch, Weimar's sometime social democratic minister of justice, the neo-Kantian Hermann Kantorowicz, who achieved some notoriety on the other side of the Atlantic for his trenchant critique of American legal realism, Theodor Sternberg, a utopian socialist who emigrated to Japan, where he pursued his interest in law and sex, and Max Rumpf, a national conservative legal sociologist who later founded the Nazi discipline of folk ethnography. In addition to coining their ideas in terms of life, these characters, as well as many of their early 20th century colleagues, had three crucial things in common. First, they were disdainful of legal liberalism, or for that matter, liberal legalism, most forcefully expressed in the German Civil Code of 1900. They critiqued mainstream jurists' view that law was quite simply what the code said it was. To late Wilhelmian life law advocates, law was free-floating, independent of legislative fiat, and expressive of a particular German sense of freedom through community and order. Law to them was to be found in life itself. At the same time, these late Wilhelmian life lawyers continued to be committed to a configuration of law as science. What they wanted to do was to achieve an adequate equilibrium between law as science and law as life, a balancing act the Nazis, of course, had no interest in, because for them, natural life necessarily trumped all intellectual artifice. Third, these late Wilhelmian life lawyers had all been educated at Berlin in the very first years of the 20th century, less than half a decade before the slightly younger Carl Schmidt, this most famous of Nazi international jurists, received his own legal education there from the same professors and teachers. And here's where I hope to have come full circle with my argument today. What my research, which, as I said at the outset, fits squarely within national German history, has to contribute to considerations of international law in the wake of Versailles, is an emphasis on the pervasive nature of life discourse in law before 1933 already, and certainly in the early Weimar period. Life law, though not quite yet racialized, was a thing as early as the 1900s. It remained a thing throughout the First World War and came back to haunt or inspire, as the case may be, law students in the newly established Weimar Republic. Life legality was not born out of a desire to make law conform with Nazi blood and soil ideology, even though it certainly came to be used for this purpose. Instead, life legality stood for a more general erosion of German faith in rootless, abstract written rules and institutions since at least 1871. The Versailles Treaty and the system it stood for simply being more of what Germans had already grown skeptical of. The alternative narrative and timeline that emerges from my analysis is thus one in which the rise of Nazism does not spell the beginning of a German turn away from liberal legality, but the culmination of 3 decades of German resistance against conventional sources of normativity by reference to life. German jurists in 1919 were skeptical about the Versailles Treaty, not only for the conditions that had produced it or for what they perceived to be its punitive content, but for the very fact that it was yet another abstract, achromatic paper instrument that threatened to undermine what Germans thought kept their nation, their culture, their people united. Not the unfeeling edicts of unfathomable authorities, be they seated in Berlin, Paris, London, or Washington, D.C., but the normative actualization of their own lived reality, the mutual rights and obligations that had characterized German living since the Holy Roman Empire. Importantly, and as I think some of my esteemed co-panelists have indicated, early 20th century Germans were not alone in their yearning for more life and less literalism, less formalism in law. The free law movement that forms the subject of my dissertation thus drew inspiration from French jurists like François Génie, and itself went on to inspire the American legal realist movement of the 1920s and 1930s. In light of this, I would suggest that an additional reason for why the Versailles system failed was a fundamental shift in German, if not transatlantic, legal consciousness away from law and towards life. Thank you very much for your attention.
Thank you very much, Katharina. And as you said, it does bring us sort of full circle. And so we have this sort of amazing moment of trying to fit the Treaty of Versailles into a broader set of transitions within legal thought in general, internationally. And what seems to appear, if we sort of bring the various papers together, is we have this kind of political economy, this political economy of legal thought, on the one hand confronted with fundamental questions of transformation in commerce, and then these two sort of radical critiques of legal formalism, a democratic critique, and then a life critique. And what's interesting is the way that these are both sort of playing off of a set of critiques of 19th century liberalism as they understand it, very much reinventing a democratic tradition that has been developing across the 19th century, and developing a critique of liberal formalism that dates back to the 1840s at the very least, right? And somebody like Karl Marx. So what's sort of brilliant in this panel is the way it forces us then to take, instead of starting from the Treaty of Versailles and saying, oh, so many flaws in this and that, if we sort of provide a deep contextualization for the sort of legal environment within which they're working, and we understand Wilson on the one hand, sort of in this transition, we understand the emergence of arbitration courts in commerce, we understand the general critique of legal formalism, and then we see that we also have these alternative visions of life law coming up. All of a sudden, the Treaty of Versailles, it looks a lot less like they made some bad decisions and a lot more like we're in the crosswinds of a massive sort of storm in legal thought, which is going to be generative for the century and obviously to come, and also clearly the 21st century. So, in the interest of time, we have time for 2 questions. We'll take them right in a row, and then we will go from there. Watherston.
Thanks. This was a wonderful panel. And listening to it, I finally understand Schmidt better and why he's so appealing right now in China and the critique of illiberal lawyer. I'd like to know if any of you could talk a little bit about Japan and what effort Japan made were they part of the discussion of law, or were they just sort of written out of it, even though they were one of the on the winner's side? Does that figure in? Were any Japanese, was there any part of it in there?
Thank you very much. Let's take one more question. Yes.
Thank you. I'd just like to comment a little bit on the roots of the world and national sovereignty.
Oh, okay. Okay. Yes. Ryan?
So, part of Versailles created a system of kind of international plebiscites, and I was just curious if any of you, in your discussion of national law, could talk about how that justification is used or kind of linked to treaty and whether or not you're convinced that there's disagreement as well as the legality of that, as in the sense that it's a form of arbitration, as people choose legally to choose the nation that they want to belong to.
Okay, why don't we only have, I hate to say this, but we really only have about 2 or 3 minutes. So if 1 or 2 of you would like to speak quickly, that would be wonderful.
Sure. I mean, I don't have very much to say about Japan, with the exception that it's interesting to look at the history of legal thought, including Japan, which received the kind of sociological jurisprudence that was mentioned several times, the kind of legal realism, the free law stuff that I was talking about very openly. So it would be interesting to pursue whether there's a connection between legal thought and foreign policy in the same way that we see in Germany and the United States.
Just to echo Katharina and to point you to the work of someone else, so not in my research, but there's a young researcher named Colin Jones who's been looking in great detail at the connection between German legal thinkers and Japanese thinkers who are drawing from it in the way that they become a part of these conversations. And so it's not my area of expertise, but there's great stuff there. And just on the plebiscite question, so I can't answer with respect to the technical question of Versailles. It is worth flagging that the plebiscite at this time is a new technology of democratic governance. So of course, in the United States, the progressive era makes the plebiscite or the referendum a key component of the way that it does democratic governance. But it's not just an American thing either. So back to Schmidt, right, a cornerstone of Schmidt's critique of the Weimar Constitution is that it incorporates a direct voice of the people alongside the parliament, which creates a kind of contradiction. And that points us, I think, towards the way in which, as a technology of democratic rule, it was a new but accepted way of doing governance. But that doesn't answer your question.
Japan was a participant in the creation of both of the treaties that the League helped produce to sort of undergird the investor-state dispute settlement system in the 20s. And as for the plebiscites, among the, there was this discussion about whether individuals should have access, but there were also parallel discussions at the same advisory committee on whether nations should be subject to international law, nations rather than states. There were parallel discussions about, and in fact, minorities did get access to the court. So a minority, like if you were a recognized international minority in one of the Eastern European states, you would have stand-in, but not in
Thank you very much once again. Fantastic way to start the day.